Hello and welcome to This Week in Polity and Governance. Today we have five very important topics that we will take up over a period of next 1 hour. First, we have the news related to Naga peace process. There are some framework agreements that were negotiated between the government of India as well as between the representatives of the Naga people from Nagaland. The government signed the agreement, but since last 9 years, there has not been any headway. There is no progress, because of which it becomes essential for us to understand the whole history of Naga insurgency in our country, the demand of Naga people, how the Indian constitution has accommodated so far these diverse demands, keeping the pace with asymmetric federalism, and what is the way ahead. Then all of us are aware about a news related to the limits of freedom of speech and expression, what becomes a reasonable restriction on freedom of speech and expression, especially on the grounds of obscenity. This has become highly controversial issue in last 10 days since the release of a clip from a very famous show on YouTube, India's Got Latent, which basically in which a YouTuber made a remark which has led to filing a lot of FIR and has rejuvenated the demands or the debate discourse around the freedom of speech and expression. Then judgment given by a particular high court in India has again brought the issue of criminalization of marital rape in our country. It has various implications on Article 14 as well as Article 21. There are both sides of the argument. Obviously, the ones which are in favor of criminalization of marital rape outweigh the other side of the perspective. So we have to understand that. Article 356 was invoked in Manipur because the government, the chief minister heading the council of minister along with the entire council of minister resigned, and that's when the president invoked 356. Article 356 is a very important constitutional provision, otherwise colloquially known as president's rule. We have to understand various dimensions of Article 356, and then a cross remark made by a High Court of Allahabad High Court has led to his summoning in the Supreme Court, and because of which the vice president has made statement that removal of any of the judges of higher judiciary is the sole prerogative of parliament as well as the president. So we'll have to understand, mainly from the perspective of prelims examination, what is the procedure for removal of the judge of high court or Supreme Court. So these are the important topics for today's discussion. Let's now move ahead and start discussing the current status of the Naga peace process. Because the National Socialist Council of Nagaland, henceforth in this discussion I will refer to it as NSCN, and a group of NSCN, IM, Isaac and Moiva, the two leaders of this particular faction. However, there was another prominent faction operating from Nepal which was known as NSCN Khaplang, but because of the passing away of this leader, that group has largely become dysfunctional. So you know that there is a tendency of rival grouping within the insurgents movement. This is one such example. Now most of the representation from the Naga community is mainly done by this particular faction of Naga groups. So NSCN IM has called upon the Prime Minister to uphold the 2015 Framework Agreement. So what this Framework Agreement is, you can see the photographs from the Framework Agreement signed in 2015, where the representatives of the Government of India and the representatives of the Naga people together signed a document as to how to take forward and resolve the peculiar issues faced by the Naga people. But the problem is that this document has not been released in public so far. So there is no document available in the public officially from the Government of India which exactly lets us know what was the document which was signed on that particular day in 2015. So whatever understanding we have is based on the statements given by few bureaucrats, the statements given by National Socialist Council of Nagaland, NSCN IM, and their representatives. So whatever discussion is going to be is not based on any authoritative document. But before we can understand and appreciate the nuances of the problem between the Nagaland and the rest of the India, you will have to understand the unique history of the Naga people, because Nagaland as a territory and Naga people in general share a very different history of association with the Indian Union. Because it was towards the very end of the consolidation of British rule, that is in 1881, around that time that the Britishers established complete control over what is known as Naga Hills. So you can see that British annexation of Naga Hills, 1878, the British shifted their headquarters to Kohima, consolidating their presence in the region. Before that, largely the Naga Hills were autonomous region, not governed by the British India. So they operated beyond the law imposed by the Britishers. After the consolidation, when the nationalist movement began in India, the same trends were reflected within the Naga community as well. When in 1918, Naga Club was formed. The representatives of the Naga formed a political association, formation of Naga Club, an organization aimed at uniting various Naga tribes and voicing their concerns to the British administration. Then, Naga Club makes a representation to the Simon Commission expressing a desire for autonomy and requesting that Naga areas not to be included within the larger Indian territory. And so we see stark absence of Naga representation in India's nationalist movement, showing clear-cut indications that they wanted to separate from the Indian Union. In 1947, before we got independence, a day prior to that, on 14th of August, the Naga people declare their independence. So India gains independence. The Naga Nationalist Council, at that point of time, the group declares Naga independence on August 14, a day before India's independence. And under the leadership of the leader Eze Fizo, the NNC forms underground Naga federal government and the Naga Federal Army. So in very similar to how a state is formed, declaring itself independent from external control, Naga people sort of form a federal government. But later on, immediately APSPA was invoked because Britishers had transferred the power to rule over the Naga territories to the independent Indian government as well. So pretty soon military rule was invoked, and it took around 10 to 15 years for the Indian government to restore law and order and to bring the insurgent forces on the table. Finally, the constitution was amended by the insertion of Article 371A, which somehow made things easier for the Naga people with the acceptance of the constitutional freedom, elevated constitutional leverage given to the Naga people. So while the provision of the federal structure of our constitution, the center-state relation would be applicable to almost all the states, when it came to the Nagaland, these provisions were modified, which meant that no law of parliament dealing with certain matters would be directly applicable to the Naga territories unless and until they are specifically passed by the Legislative Assembly also. At the same time, both the civil code as well as the criminal procedure in matters dealing with Naga people within the territory of Naga would be entirely written by the Legislative Assembly of Nagas. So you can see to what extent the Constitution of India can go to accommodate the varying regional demands. And this Article 371A was included almost at the same position where you have special provision for Jammu and Kashmir, 370, then 371 dealing with Maharashtra, and then 371A dealing with Nagaland. So temporary and transient provision of the constitution were all packed together at one place to kind of persuade different regions to at least be in Union of India, and Union of India also showed the flexibility to accommodate their demands. In 1997, finally a ceasefire was signed between the main insurgent rebel group, NSC and IM, and that's when they laid down the arms. The terms and conditions of the ceasefire were helpful to both the sides, especially to the fighters of NSC and IM, where the state of India guaranteed immunity to all the people who had taken up arms against the state of India. And then in 2015, finally, a framework agreement was signed between the government of India and NSC and IM to outline the future relationship and work towards a final settlement. As I have already said, there are no clear-cut indications. There is no authoritative document which can exactly pinpoint to us what was actually signed. But we have few details gathered from different sources which actually can help us pinpoint some of the common agendas signed between the Indian government as well as the representatives of the Nagas. Number one point that was signed was that the government of India and the state of India would recognize the identity of the Naga people. unique history, culture, and position of Naga in Indian society that would not be trampled with and would be protected by the Indian Constitution. Now, this is what agreement says. What are the finer details? We don't know, but this is what the representatives of the NSC and IM have said. This was signed on that day in 2015. At the same time, the government of India agreed to share sovereignty with the Naga people. Now, you can understand sovereignty is crucial for the state formation. In fact, sovereignty, being internally supreme and externally independent, is one of the first qualities to create an independent state. Now, sharing of sovereignty is an essential part of federalism. That's what federalism means, shared sovereignty, which means that the state legislature also has the power to make laws, whereas parliament also has the power to make laws, as opposed to a unitary state where all the power to make laws is a monopoly of a single parliament at a single level. Now, in what ways, in what terms the sharing of sovereignty was agreed, no one has any idea. But what the people of Naga, the representatives of NSC and IM have said is that the government of India agreed to the continued autonomy of Nagaland as a state, which meant special autonomous arrangement with enhanced executive, legislative, and judicial powers given to the representatives of the Naga community. Now, of course, we have no certain way to exactly either agree or deny this information which comes mainly from the NSC and IM. Unless and until we have a representative of the Naga community, there is no way we can actually pinpoint what actually happened in these particular areas, in this particular document. Also, a very peculiar demand of Naga have since the beginning has been to consolidate all the areas where Nagas live. Now, Naga is not a particular single tribe. It is a combination, consolidation of a large number of tribes together known as Nagas. Now, their population is distributed not just in Nagaland, but as you can see, that's why I put up this map. If this is the territory of Nagaland, the Naga tribes are scattered in Assam, they are scattered in Arunachal Pradesh, they are scattered also in Myanmar and in Manipur. So initially the demand was to create a Naga limb combining the entire territory where Naga tribe resides or inhabits. Now obviously that is impossible. So now the demand has been to take up the territory from Arunachal Pradesh, Assam and Manipur and create a state of Greater Nagaland. That has been the demand of the Naga people, to which NSCM IM says is that there will not be any immediate changes to the state boundaries despite aspirations, but nonetheless, this is what the Naga people want. But the government of India at that point of time did not agree to the reorganization of the political boundary within Northeast. And so all the issues that the Naga community faces will be peacefully resolved. Now this was signed in 2015, and as soon as slowly and gradually there was a huge victory claimed by the government of India, because this was the first time a formal agreement was signed after 20 to 30 years. And out of all the problems that we see in Northeast, most of them have been resolved except the one in Nagaland. And so this was claimed as a huge success in political negotiation by the Modi government, which was in power back then also. But no headway was found over a period of next 4 to 5 years. But suddenly, we saw the revocation of Article 370. We saw how special status of Jammu and Kashmir was not only taken away, but also it became the first state to transition from the higher elevated sharing of power in the form of state to literally becoming an extended part of Delhi, which means Union Territory of Jammu and Kashmir and Union Territory of Ladakh. And that's what mainly sent shockwaves in Naga community, that if the government of India, Union of India can do this to the people of Jammu and Kashmir, what prevents the government of India going back on framework agreement, and what prevents the government of India to basically go back on all the promises and take away whatever status, special status that has been provided so far in the form of constitutional guarantees in Article 371. But immediately it was followed by COVID, so 2-3 years there was nothing. But now when we saw things resuming since last 1 year, there has been heightened pressure from the Naga communities to reinitiate and find a solution to this problem. So, why the problem has emerged lately is or can be divided into the issue of separate flag and constitution, framework agreement and its contrasting interpretation. Because of the vagueness of the agreement, both the government of India as well as the representatives of the Naga community interpret to their best interests. Internal divisions. When Mr. R.N. Ravi was governor of Nagaland, he sort of helped all those factions within Naga community which are opposed to NSC and IM just to create a rival group within Naga people, which actually unnerved the NSC and IM, and now it's not feeling well because now it feels that there is a competitor to negotiate on behalf of the Naga people. And then you have no clear time frames. No clear time frame means that when the agreement was signed, within what time both sides should actually find resolution to these problems was also missing, and that has pushed the NSC and IM to create renewed pressure on the central government to take forward and find a solution to the Naga problem. So this is the entire understanding of the issue of Naga people so far. How are we going to resolve this Naga problem is something that remains to be seen. However, there are certain principles that cannot be overlooked. Principle number 1 is involving all the stakeholders into the negotiation process. That is the number 1. Second, always resorting to peaceful means is something that should be stuck by both the sides, the government of India as well as the representative of the Naga people. At the same time, the options are available within the Constitution of India. The Constitution of India has shown all its flexibility when you look at the previous responses to insurgencies. The government of India, the state of India, and the Constitution of India is very flexible. So when you have an emergent new regional demand, it can accommodate such demands under the provisions of Article 244 Clause 1, which means 5th schedule. If that does not satisfy the aspiration of some people, it can go beyond that to provide the responses in 6th schedule, creation of autonomous districts and councils. If that is also not sufficient, you can create elevated autonomy and also a new state. If that is also not up to the satisfactory level, you have seen that various states in our India get special provision that violates the general equality principle of federalism as seen in US, but Indian Constitution ingrains the idea of asymmetry to accommodate the diversity. And that's when you can see that all the options are available within the framework of Indian Constitution. Does that make sense? So you can see that these are certain general principles that should always be followed while negotiating any new demands for Naga people. Next news is, what does Indian law says about obscenity? So Assam police has registered complaint against YouTuber Ranveer Ahluwalia and comedian Samay Raina for allegedly making obscene remarks during an appearance on the YouTube show. They have been charged under section 296 of Bharatiya Nyaya Sanhita 2023 and are currently under investigation by Mumbai police. Now, if you look into this matter, you can clearly see that this fundamentally deals with Article 19 and the restrictions on our freedoms. Every citizen in our country has been granted right to freedom of speech and expression. But just like any other freedom, this is also subject to limitations. When your exercise of freedom starts impinging on other people's exercise of freedom of speech and expression, when it starts adversely impacting other people, then that's the limit. Now the question is, who decides what that limit is? So the first limit on our exercise of freedom of speech and expression comes from the Constitution itself. If you look at the Article 19, all citizens shall have the right to freedom of speech and expression. However, Article 19 Clause 2 talks about nothing in this sub-clause 1a, which means nothing here, shall prevent the state from making any law, insofar as such law imposes what? Reasonable restrictions on the exercise of the right, which means on the exercise of freedom of speech and expression in the interest of, number 1, sovereignty and integrity of India, security of the state, number 2, friendly relation with foreign countries, number 3, foreign states, public order, number 4, decency and morality. So the Constitution of India provides power to the state to restrict everyone's or anyone's freedom of speech and expression if it is obscene, indecent, or immoral, which also means that first the state will have to make a law, pass an order, only then it can be curbed. And so the state of India has created many laws to restrict people's freedom of speech and expression on the grounds of obscenity. And in fact, obscenity is a criminal offense in India, which can lead people into at least 3 years of imprisonment, in many cases 5 years, depending upon whether it is a first time offense or it is a repeated offense. So you can see that there's section 294 of Bharatiya Nyaya Samhita and section 296 of Bharatiya Nyaya Samhita provide for restriction of obscenity. Whereas section 67 of IT Act talks about obscenity over digital platforms, and then there is a law dedicated to prevent the indecent, prurient sexual representation of women. And so these are mainly the 3 provisions, 3 laws which try to restrict the obscenity exhibited in various forms of speeches as well as expression. The problem, however, is nowhere obscenity is defined. At the same time, it is extremely difficult to define what is obscene and what is not obscene. More often than not, we have seen it is the other people's perspective which sets the boundary on our freedom of speech and expression. For example, hate speech also is a reasonable restriction on the freedom of speech and expression. But what is a hate speech or what is not a hate speech? Generally, the hate speech laws in India give veto to a minuscule minority in the society, because there are provisions in the penal codes like Bharatiya Nyaya Samhita and erstwhile IPC which prevented people from using language which might injure the reputation of a religion or a group or a caste, which basically means that criticizing caste system can also invite the invoking of criminal offenses. So definition of obscenity is missing in constitution. Obviously it has to be, constitution cannot define, otherwise it will never end, but it is also missing in law. And so we are largely dependent upon the judicial doctrines to set or determine what can be categorized as objectively obscene or what cannot be categorized as obscene, and hence people are allowed to express in those ways. Right now, the courts, the Supreme Court and the High Courts have adopted a doctrine of community standards. While evaluating whether a particular speech or expression confers the test of obscenity or not, or fails the test of obscenity, the courts apply community standard test. What is community standard test? In Avik Sarkar versus State of West Bengal, the court specified that regard must be made to the contemporary and national standards and the changing notions of obscenity. Number one, we will never stick to a static notion of obscenity, because as the society evolves, what is obscene and what is not obscene, that differentiation also keeps on evolving. For example, portrayal of women in bikini in 1950s could have led to obscenity charges, but because the society has evolved in such a way over a period of 75 years that does not breaches the benchmark of obscenity as it exists in the overall general society and the entire nation. So regard must be made, a reference has to be made. Not that it can set the limit, but the reference has to be made to the contemporary and national standards, because whatever is the contemporary and the national standard, you cannot breach that limit when you are a part of that state or territory. Then the test considers the dominant theme of the material as a whole, which means that in this particular case, the court will go and watch the entire episode to determine what is the dominant theme of this particular show. Now, while trying to determine the dominant theme, you can clearly see that in the entirety of the episode, this is one of the remark which is questionable. We don't know whether it will be designated as an obscene or not, but the dominant theme of the show, whether it deals with incestual relationship or prurient thoughts of the people or largely sexual, if because it is the dominant theme of an artwork, dominant theme of a speech, of a book, of a novel, of a cinema, that matters, not some random scene or one of the off the cuff remark made in a particular statement or in a large body of work. That is not going to determine the fate of a particular speech and certainly expression. That is a remedy that they are looking for, because this is the test right now. Then it asks whether the average person would find the material prurient interest. Take an average Indian, not the extremely liberal, neither the extremely conservative Indian. Take on an average Indian. And if you take that average Indian, according to the thought process of the judiciary, will that average Indian find it to be extremely offensive or not? And so that is what going to determine the limits to obscenity, limits to freedom of speech and expression, and where the speech and expression becomes obscene. It also considers whether the material lacks serious literacy, literary, artistic, political, or scientific values, which will come to it right now. But this is something that generally is not applied in Indian case. And that's why more often than not we see more and more number of material being labeled as obscene. Because in a diverse country like India, the social norms of what is obscene and indecent and what is not obscene and not indecent varies drastically from one community to another, one region to another. In fact, it could also vary from one caste to another, one religion to another. And so, a uniform national standard of values regarding obscenity does not exist in India because these doctrines emerged in West, in US and Canada. We have automatically adopted them. But these are largely homogeneous societies. But India has many layers of variation. It operates on intersectionality as well. And that's why the number one problem with regulation of obscenity in our country, especially by judiciary, becomes that there are no uniform national standards. So maybe the judiciary should resort to differential standards depending upon which region or which language this particular work particularly caters to. Then the second problem is that the Indian courts, while deciding on the obscenity of particular material, have not known to gather objective evidence as to what national standards are. So while national standards are difficult to be conceived in a diverse society like India, the second fundamental problem is that judges, while articulating that this is what average person might consider as extremely gross, offensive and obscene, the judiciary and the judges do not clearly objectively write down the parameters which led them to believe so. And there you can see fundamental deviation from the rule of law, which basically means that ultimately the limits to the freedom of speech and expression will be drawn by the personal morality of the judges, which is again a fundamental violation of constitutional morality. So the ideas of what it means is that if the case ends up in the court of a conservative judge, and if the same case goes to the court of a liberal judge, the outcome of the same process would be extremely difficult. And that's what the problem with India is. And the third problem with India is what these two guys are going through. Right now, they have not been proven guilty, but still they had to remove all the content from social media. Because first they are terrified, and secondly, the automatic injunction handed out by the judiciary, the automatic stay order given on a creative expression, before even you are proven guilty. So when an FIR is lodged and the case or the trial initiates, even before that, the artistic expression has to be expunged from wherever it exists. Now, after 7 to 8 years, if the case ends and maybe if they are vindicated from the court, they are exonerated from the court, maybe they can resume the artistic expression. So you can see eventually they might not be proven guilty, but the process has itself become a sort of punishment for a creative person. And so that's why you see increasingly the tendency to self-censure in India. That's why these kinds of provisions have extremely chilling effect on the freedom of speech and expression. And that's why the editorials have talked about reform of obscenity laws and reform of doctrines within judiciary. So apart from the community standard test, that what an average Indian is thinking, you should adopt, add it, supplement it with two more doctrines that now prevail in Western society, where we see elevated protection given to freedom of speech and expression, is the doctrine of patently offensive and doctrine of no redeeming social value. What does these two terms mean? If a particular artwork or freedom expression or a speech comes up as a patently offensive, like hardcore porn, it is patently offensive. So there is no need to even discuss whether to ban it or not to ban it. However, there can be a debate if there is some social value to be derived from that artwork, which is what I said, whether it is a serious literary, artistic, political, or scientific value. For example, when I said hardcore porn is patently offensive, what if the same sexually explicit material are being shot to make people aware about sexual acts or for medical safety? What if the same work is being produced for educational purposes of reproductive health? There are many paintings drawn by famous painters across the globe which are explicit and full of nudity. Why do we protect them? Because there is a lot of artistic work which has led to the creation of such content. So you can see that it is ideally the combination of the three principal: community standard test, patently offensive, and whether you can derive certain social value which can ultimately save even an explicit or an offensive content. So only when you combine the community standard test along with these two, that you are likely to arrive at a scene of freedom of speech and expression in our country, which is which ultimately does justice to the people in terms of really clearly identifying what is really objectively obscene, and then allow the freedom in rest of them to be expressed. So this is the discussion on the topic of the second topic. Let's now move on to the next topic of discussion, which deals with the marital rape. The constitutional validity of marital rape, enforced sex or intercourse within a married relationship. Now, why this has come in news is because the High Court, Chhattisgarh High Court, has reversed the judgment of a district High Court where a woman was killed supposedly by the husband, and rape charges were also included. So the rape charge has been revoked, whereas the person can ultimately be tried for the murder. Now, the problem is that in India, there are various laws in the protection of women. So there is Domestic Violence Act, there is an provision which criminalizes the act of dowry. Then there are provisions which criminalize the intercourse with minor women. There are provision of rape, and rape has been very widely defined, not just as a penetrative sex, but forced oral sex also becomes a punishable offense in our country. But there is one category of women to whom no such protection is available, are married women, because forced intercourse on married women by her husband is completely exempted from the category of cognizable criminal offenses. And that's what the debate. But the debate started not just after this judgment. The debate goes back when we were undergoing the trial for the decriminalization of homosexuality as a part of section 377 of erstwhile IPC, which provided for unnatural intercourse to be categorized as offenses. Whoever even voluntarily has carnal intercourse against the order of nature with any man or women or animal shall be punished with life imprisonment or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. The explanation of the same section carried penetration is sufficient to constitute the carnal intercourse necessary to the offense described in this section. Now, this particular law was not entirely decriminalized, that was not completely struck down, only as it dealt with voluntary carnal intercourse between men and women was struck down, whereas rest of the sections were retained. There are certain good things with such decriminalization, but there are certain bad things also. But before that, let's understand how Article 14 and Article 21 provided for striking down of the Section 377 or decriminalization of homosexuality. When this particular section was challenged in the Supreme Court, we already had case Puttaswamy judgment, which had read privacy as a part of fundamental right, which meant the deprivation of privacy will have to be based on or will have to be subject itself to the three claims specified in K.S. Puttaswamy judgment. The number one would be the legitimate interest of the state. In violation of the privacy, there should be some justified state interest, only then the privacy can be violated. So for example, national security, legitimate interest. But can you automatically deprive people of their privacy? No, it should be based on legality. There should be a law to deprive people of the privacy. And then the element of proportionality. The infringement of privacy should be proportional to the state interest and not disproportionate to the state interest. Now, if you have privacy as a fundamental right, you can see Section 377 will have to go, because the state has no legitimate interest to find out who are the people who are having intercourse with or without the same gender. So that's why it became the ground. But it also fundamentally violates the Article 14, because Article 14 provides for the freedom to the state to carry out reasonable classification. That is what equal treatment means, equal treatment of equally situated. Now, reasonable classification, or what determines the reasonability of the classification, is dependent on two parameters which I have already discussed, in previous focus videos: intelligible differentia and rational nexus, connection with the purpose that is sought to be achieved. Now, if you look at the purpose that is sought to be achieved in the previous section, it is protecting or preventing unnatural offenses or unnatural sex. So if the state is to prevent people or animals from unnatural sex, then what should be the differentia? How will you, so let's say these are different kinds of sex in which you want to draw a boundary where you will put natural intercourse on one side and unnatural intercourse on another side. What is the differentiating parameter which you draw? Supreme Court said when two consenting adults indulge themselves into intercourse, into sexual pleasure, the only thing which can draw the line between natural and unnatural is the consent. So the consent becomes the only valid intelligible differentia which has the nexus with the purpose that is sought to be achieved. Now, if consent becomes the differentiating factor between natural and unnatural sex, then any kind of sexual interaction, intercourse which has consent is not criminal, but any kind of interaction, sexual intercourse which does not have consent will have to be criminalized, which paved the way for decriminalization of homosexuality in our country, because Article 377, Section 377 provided for unreasonable, evasive and artificial classification of the sexual intercourses. Now, if consent becomes the marker, consent becomes the intelligible differentia, becomes the basis for reasonable classification, Then on this side, you have all what is not criminal, but on this side, wherever the consent lacks, should ideally be designated under the category of rape. And so immediately the question was, what if a woman is under the married relationship, but the intercourse forced upon her lacks consent? Would you not criminalize that act? Supreme Court stopped at that point of time because it said we are not going to interfere into social institution, and marriage is a very strong social institution. So maybe Parliament can go ahead and amend the laws. But after that, Parliament passed a law, and look at the law. Offense of rape in Bharatiya Nyaya Sanhita. A man is said to commit rape. So first, the rape is defined only in terms of man versus woman and not the other way. And that's why you needed something like 377 to protect men against forced sodomy or anal sex. A man is said to commit rape who has sexual intercourse with a woman under the following circumstances: against her will, without her consent, with her consent, but consent has been obtained because of putting her in the state of fear of death, when the man knows that he is not her husband, but believes that he is her husband, which means husband are off the hook. Unsound mind or intoxication with or without consent forms the rape. And then there is an explanation just below that, which says sexual intercourse or sexual acts by a man with his own wife, the wife not being under the 18 years of age, is not a rape. So the forced sexual intercourse over a major wife does not constitute a rape. Only over a minor wife violates POCSO, and that's why it would be categorized under the. So that's why the debate has again started whether to criminalize the marital rape, because once you criminalize the marital rape in our country, a lot of the advantages are yielded because it is against individual rights of married women, and so it fundamentally violates the principle of Article 14 as well as Article 21. It violates Article 21 because the life is incomplete without dignity, and forced sex on women, even in a married relationship, violates the dignity of women. So it violates Article 21 in that sense. It is also a violation of Article 14 because it is a violation of both equality before the law. At the same time, it is a violation of both equal protection of the laws, because you are not treating all the women as same, and you are differentiating non-consensual intercourse in a married and in a non-married relationship. Also, forced intercourse is a kind of domestic violence. Both mental as well as physical torture is domestic violence in a married relationship, which has already been criminalized. So a married man cannot beat his wife, but can do anything while doing the sexual intercourse, which becomes not an offense in our country. Also, it is inconsistent with other laws and judgment, because various times, I'll give you, you can read the whole article, the Supreme Court has explicitly said that this should be criminalized. At the same time, affidavit filed by the government of India has clearly said that this might violate some of the laws which we have. It might come in confrontation with some of the other laws, so it is incongruent, and so it is a matter of time that it should be criminalized. However, there are equal arguments because of which government does not seem to be willing to criminalize the marital rape, which is that marriage as an institution will be under threat, especially when we see so many laws that are oftenly reported to be misused, just like dowry. Any law is liable to be misused against people. But we have seen a lot of misuse of Dowry Protection Act. We have seen misuse of Domestic Violence Act, where ultimately the family of the groom was vindicated, but they had to go through mental harrow of the judicial trial, and that's why it creates a problem. So you can see that the marital rape as a problem exists. National Family Health Survey reported around 5.1% women going through marital rape. But because of the economic dependence, because of the sanctity of the marriage as an institution, they do not come out and admit openly about the forced brutalities going on inside the homes. And that's why some action should be taken. We are not arguing, you should not argue for immediate criminalization of marital rape, but at least some measures should be taken. You let us know in the comment section what that step could be while we move on to the next topic of discussion, which is the invocation of Article 356 in Manipur. 4 days after the resignation of Chief Minister of Manipur, President's rule has been imposed in Manipur. In this context, let us understand history of Article 356, its application, issues arising, and the way forward. So we know that the provision of the emergency provision contained in the Indian Constitution provide for different kinds of emergency. So we have Article 352, which talks about national emergency on 3 specific grounds. Then we have Article 356, imposition of President's rule in a particular state. And then we have financial emergency under the provision of Article 360. All of them have different purpose, all of them have different procedure. Why this provision was created? To allow the president takeover of the constitutional machinery of a particular state, because you can understand that the genesis of India was born under the fear of separation, secessionist activities, violence, and centrifugal forces acting at the time of creation of the state. And so it was felt necessary by the Constituent Assembly to include a provision so that whenever a particular state is seen not to follow the constitutional provision or violate them, then immediately the central government can take over the governance of that particular state to not allow the progression in that sense. So first, let us look at the procedural part of Article 356 so that we can discuss the analytical part later, because this is extremely important from the point of view of prelims examination. There are 3 articles which base themselves into invoking Article 356, because Article 356 says that only when the governor is convinced that the constitutional machinery has broken down in a particular state, only then the president rule can be invoked. Not that there is a corruption, not that there is a law and order problem, not that there is a high inflation, because these have also acted as a ground for invoking Article 356. So the specific mention in Article 356 of breakdown of constitutional machinery can be the only ground for applying the president rule. Now, which means that the government cannot be carried according to the provision of this constitution. So what are those? These provisions are scattered around in the constitution. Article 251 says all the laws made by the state legislature have to be in consistency with the central parliamentary laws. Article 256 says the executive power of every state shall be so exercised as to ensure compliance with the laws made by the parliament. And then we have Article 365, which says that failure to comply with or to give effect to the direction given by the union would be sufficient to say that the government of a particular state cannot be carried out in accordance with the provisions of this constitution. So you can see that when the orders of the central government are not followed in a particular state, when a state legislature makes a law which openly violates or goes against or is incongruent of the laws passed by the parliament, and that's when Article 365 gives it the power to the governor that it is justiciable. It is okay to now believe that the government of a particular state cannot be carried out in accordance with the provision of the constitution, because these are the provisions of the constitution which expect the state to follow the orders of a central government. These are the provisions of the Constitution of India which expect the laws of the legislature to be consistent with the laws of the parliament. And also there is one more provision under Article 355 which says that it shall be the duty of the central government to protect every state. So if the state is not able to protect itself, then also, but I have not written it there. So the government cannot be carried out according to the provision. If this is yes, then obviously go ahead. If this is no, please do not impose. After the governor is satisfied, the governor will write down a report, and the report will be sent for presidential proclamation. The president, yes, obviously immediately can notify president rule. However, within 2 months period, through the simple majority of both the houses, it should be validated. So there is a parliamentary approval included Otherwise, if the Council of Ministers at the central level, they fail to satisfy this condition, then within 2 months of period, the president rule will no longer hold in that particular state. So if they do it, then it prolongs for 6 months. Then it will have to renew it if they want to extend the period of president rule beyond 6 months, but they can only do it for twice, or which means 1 year. Because more than 1 year, if you want to perpetuate Article 356 in a particular state, then either of these two conditions should exist. Either there should be a national emergency in the entire country, then you can go for the extension third time. Or if the Election Commission of India gives in writing that the condition of the state does not allow us to conduct a new fresh election to the Legislative Assembly, only then it can be extended for the third time. In no way it can go beyond 3 years. Before 3 years, you will have to get the election done and remove or revoke Article 356. What are the effect of Article 356? The president can assume to himself any of the powers of the state government. High court power cannot be assumed. So high court powers are intact in case of Article 356. The proclamation can declare that the powers of legislature shall be exercised by or under the authority of the parliament, and then delegation to president who can further delegate such authority, and then the law can be made. So you can see that there are various delegations that happen. Through the proclamation, the president can transfer the lawmaking power to the parliament, and then parliament can transmit the lawmaking power to any authority that it thinks fit for the time being. At the same time, the president can authorize, the parliament can authorize payments from the consolidated fund of state if the House of the Parliament. So you can see that these are the powers that they get delegated. Why Article 356 is always in news is because of its misuse from time to time. Because misuse of the directions from the state is as vague as it can be. Biased report from the governor. Mainly, it is the governor which has always created a problem. We have seen now the reduction in the use of Article 356 with time, and there are reasons for it, which already has been asked, and we discussed this in mains QIP as well. So look at the provision and the grounds on which Article 356 can be invoked. Orders issued by the government not followed by the state government. Now, these are very vague provision. What constitutes an order from the central government and what constitutes a violation? What constitutes an incongruency between a state legislative law and a parliamentary law is not clear. Also, because the governor itself is an extremely political appointee, continues to behave as a long arm of the center, the use of Article 356 is always at the interest of the central government. So in past, we have seen various governments have misused these provision to the level that the Supreme Court had to intervene in terms of pronouncement, and that's one of the reasons why the use or misuse of Article 356 has declined over time. Now, in this regard, National Commission to Review the Working of the Constitution has recommended certain provisions which have not been added in the Constitution, but which have found their place in the judicial pronouncement. It said that before you can dissolve the Legislative Assembly of a particular state, make sure, even before you can remove the Council of Ministers, make sure that there is a mandatory floor test to prove the majority, to prove the responsibility. If the Council of Ministers continue to be responsible, doesn't make sense to, remove the Council of Ministers. Proclamation along with annexure specifying the grounds of constitutional breakdown, publicly notify and let the entire country know what was the specific violation of Article 256, 251, 257, 365, 355 that became the ground for invocation of Article 356. Generally, it is not revealed. In this case, it is obvious. Manipur is not a misuse, but previously it has been misused where no one actually knew why a particular government was removed. More often than not, it was removed to serve the political ends of the central government. The mechanism shouldn't be deleted but be used as a last resort. So it did not recommend the removal of this particular provision. It has its own utility but should not be misused. No dissolution of the legislature before the proclamation laid down in the parliament. So you can see that Removing the Council of Minister does not disband the Legislative Assembly automatically. It has to be issued by another proclamation which transfers the power of the Legislative Assembly to the Parliament. The National Commission to Review the Working of Constitution said you can remove the Council of Ministers, but that does not mean you will dissolve the Legislative Assembly. You can only do so once the proclamation is approved by both the houses within 2 months. Once that happens, only then you can, but it is not mandatory. But what we see generally is that Council of Ministers is removed, the executive is taken over by the central, and immediately the Legislative Assembly is dissolved, because the interests that were supposed to be served were political. And so if you do not dissolve the Legislative Assembly, it doesn't make much sense to invoke Article 356 in many cases. And so we had Supreme Court judgments where the SR Bommai case proclaimed federalism as an essential part, and it laid down certain criteria in which the Article 356 can be used, which basically specified that the report sent by the governor to request Article 356 invocation should be a speaking document, should clearly lay down the grounds as objectively as it can, justifying the breakdown of the constitutional machinery and justifying the fact that the governance of the state cannot be carried out according to the provision of this constitution. Also, why its use has declined in previous time is because of the Supreme Court judgment, where now the governor reports are subject to the standards set in prominent judgments. Also, we have seen the emergence of regional parties with time, which have formed the coalition government at the center. Now, if you have a state government which also is participant in the national government, then the use obviously will decline. Earlier, it was just the hegemony of the Congress, and the Congress was in most of the states. So Congress continuance in power was not contingent upon the support by the regional parties. But as soon as we see, we had a phase of coalition starting from 1989, ending in 2014. So that's why the use of Article 356 declined, because any national government was supported by so many regional parties. And so also a kind of realization has dawned upon even the central government that in long-term perspective, if you see, this misuse of Article 356 does not serve any purpose, and that's why better that we should not use it too often. There have been various valid uses, for example, the one in Manipur, because of which we are discussing it, to restore peace and order in Punjab, in the backdrop of Khalistan insurgency, where Punjab was under president rule for more than 3 years, and that's why the constitution had to be amended to provide for extension beyond 3 years. Then after the demolition of the Babri Masjid, the structure, the 3 BJP governments were removed, and that was justified by the Supreme Court judgment also, because both federalism as well as secularism are the basic structure, they are part of the basic structure of the Indian constitution. And also when the political crisis in UP began, where no government alternative could be found from the Legislative Assembly, then it had to be dissolved and the governance had to be taken by the central government. So these are valid uses. Now let's now move on to the last article for today's discussion, is the removal process of Judge of High Court. The Rajya Sabha chairman asserted that only Parliament has the jurisdiction to constitutionally remove a High Court judge. His remarks come in the context of the Supreme Court summons to Justice Yadav, a judge of Allahabad High Court, to appear before senior judges of the Supreme Court regarding his communally charged remarks. Now, because of which, let's quickly revise the provision. What you see in the bold letter are the constitutional provision. Rest everything that you see in small letters are the provision provided by Judges Inquiry Act of 1968. So the grounds for removal of a judge of a High Court or a Supreme Court are only two. Either it is proven that they have committed a misbehavior, or they are incapacitated, and in that sense they are unable to perform the functions. So the Constitution of India says that if judge is found guilty of proven misbehavior and incapacity, then by the address of each house of the Parliament with a majority of half and 2/3, if that is done from both the houses, then through the order of President, the judge of the High Court or Supreme Court can be removed. But the Constitution also says that the other procedure shall be clarified by the Parliament by parliamentary law. So Parliament means Judges Inquiry Act 1968, which says that the initiation of a resolution should come from 100 members of the Lok Sabha or 50 members of the Rajya Sabha. Then after a resolution submitted by 100 members, let's say goes to the presiding officer, then presiding officer may either admit or refuse to admit the motion. So that option is available to the presiding officer, that she or he might admit or reject. And if in case they reject, there is no moving ahead. Then the speaker or chairman to constitute a committee consisting of a Supreme Court judge, a judge, Chief Justice of High Court, and a distinguished jurist. And only if that committee finds out, they table the report in front of that house, and the same procedure will be repeated in the second house. And if both of, in everything, if all of this is done in one session of the parliament, only then it will go to the president, and then the president might sign or might not sign. So that safety is also available. So you can see the removal process of High Court and Supreme Court judges are extremely difficult. That's why none of the judges have been removed. Supreme Court, none have been removed so far. The resolution has been taken up, but it could not be completed in one session. So that's the problem. So these are the important topics for this particular week's discussion. I hope it has been helpful. Stay tuned on our channel. We upload content on our IAS Compass website. So all these articles that you have seen, and 2-3 more articles, you can go to the IAS Compass, and all the subjects current affairs is, as well as the static articles, are published very frequently on a daily basis on our website. You can join and subscribe to our Telegram channel for more frequent update. Thank you. Have a good day.